Hello, Genius, and welcome back to the Own Your Genius podcast, the space where we encourage you to use your education and your experiences to create dope businesses. I'm your host, brand attorney LaKanya Murray, owner of Mark IP Solutions and founder of Mark Legal. A week or so ago, I came across this post on Threads where the author essentially said something like that there was a reason that they only posted certain content online and that there weren't enough IP attorneys talking about how people can protect their content from AI. Fair enough. I get it. The challenge is when it comes to AI and copyright is that the law is playing catch up and that the courts are trying to apply the laws to situations that weren't contemplated when the laws were enacted. So despite this, though, I do believe that we can find some guidance in how to handle these situations by remembering why copyright laws exist in the first place, which is to foster creativity. So if people know that the work can be copied freely, then they're less likely to invest their time, money, and energy into creating. But, right, if the law gives them control, they're more likely to keep creating and society benefits from that creativity. So we want to make sure that that is protected. One of the concerns that people have is that their work can be used to train AI. Today, I'm going to discuss a case that's at the heart of this discussion, Kadri versus Meta, and we have a good one for you today, so let's get started. Welcome back to the Own Your Genius podcast, where we talk about building smart businesses, creating standout brands, and turning your intellectual property into income. I'm your host, attorney LaKanya Murray, founder of Mark IP Solutions. We're a boutique firm that helps professionals and experts use legal clarity and brand strategy to protect what they've built and grow what they've created. We got a good one for you today, so let's get started. So what is this lawsuit? It's Kadri versus Meta. I might have messed up that last name, but it's Kadrey versus Meta, as in Facebook, in case you want to go and just get updated on the case. I'm going to provide a summary. So essentially what this case is that 13 authors filed a lawsuit against Meta. They claim that Meta downloaded their books from unauthorized online libraries and used them to train this AI model. It's called Llama, and they did this without paying for their rights. Llama is Meta's language model. It's a type of AI that learns how to write by analyzing massive amounts of text. The better the training data, the better the model will perform. That's why books, which are well written and structured, are especially valued to this training module. Meta used these books to help Llama generate human-like responses, summaries, and even creative writing. So what they're claiming in the lawsuit is this. The authors are alleging a large range of claims, including direct copyright infringement, meaning that, Meta allegedly reproduced their books without permission. Vicarious copyright infringement, meaning that Meta allegedly benefited financially from the infringement while having the ability to stop it. They also claimed a DMCA violation, which is alleging that Meta allegedly removed or ignored copyright management information, which is protected under the Digital Millennium Copyright Act. They also allege unfair competition, which alleges that Meta's actions by allegedly downloading these books, and actually it's not, the downloading part is not alleged. They say, we did do that. But the authors or the plaintiffs are saying that by downloading those books and taking the actions that they took, that it gave Meta an unfair advantage over their competitors who actually follow the copyright rules. They also allege unjust enrichment, meaning alleging that Meta allegedly profited from the author's work without compensating them. And they also allege negligence, right? Negligence by allegedly failing to take reasonable steps to avoid infringement of the author's rights. And later on, they added another claim, which is distribution claims, meaning that not only did Meta download the books, but they're alleging that Meta might have re-uploaded them during this process when they were trying to train their AI, which would be potentially sharing the books and the content with others. All right, so those are the claims. Why does that matter? Why does any of this matter? So copyright, they essentially give a bundle of exclusive rights, and those rights include the right to reproduce their work, which is make copies, the right to distribute their work, which is to share or to sell it, to create derivative works like adaptations or translations, or publicly display or perform the work. Those are the rights that you get as a copyright author. Now, these rights are here to make sure that your creative genius is protective and ensure that you can profit from your work. But there's a twist, right? There's a twist. The law also has exceptions. Whenever someone asks a lawyer, blah, 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 be true, the answer is always, it depends, right? Because when it comes to the law, 9 times out of 10, there are some type of exceptions that apply to the situation, and we have to take that into consideration. So in this case right here, when we say that only copyright owners have the right to reproduce, distribute, create derivative works, or even publicly display or perform the work, there's also an exception. And that exception, one of the main exceptions, is fair use. So fair use, which is a legal defense, is an exception that lets other people use copyrighted material without permission in certain cases, like for education, commentary, or research. There are 4 factors that come into play when we're talking about fair use, and that's the purpose of the use. Is it a commercial use? Is it an educational use? Is it transformative? The nature of the work. Is it factual or is it creative? How much of the work was used, meaning how much was copied, and what's the market impact, meaning that will you using this work in the way that you're using it without a license, will it hurt the creator's ability to earn money? So in this case, most of those claims that we talked about earlier were dismissed early on, with the exception of the direct copyright infringement and the distribution. Those 2 were still pending. Both the plaintiffs and Meta, they both filed for a motion for summary judgment to determine whether or not Meta's use of the books to train AI was fair use. A motion for summary judgment is a legal request asking the court to make a decision based on the case or a specific issue without a full trial. Basically, they're arguing that, hey, the facts, we don't have an issue with the facts. The facts are what they are, meaning in this case, Meta and the plaintiffs both agree that Meta accessed these books from this online source and downloaded the books and used those books to train their AI system. That's the facts that are undisputed. So they are asking the courts in this case to say, based on these facts, apply the law to it and give us a decision. We don't need a jury. So that's what a motion for summary judgment is. You typically write the motion and the courts can hear arguments on it sometimes, and then sometimes they just make a ruling based off your written arguments. In this case, the plaintiffs argued that Meta copied their books without permission, that Llama, the AI training model, could reproduce snippets of their work, and 3, they argued that Meta's actions could hurt their ability to license their books for future AI training. And in response, Meta said essentially that the use was transformative. Training an AI is different from reading a book. They said that Llama couldn't reproduce enough of the books to matter. I think in the order I read that Meta claimed that it couldn't put more than 50 words together of the same passage. Like no matter what the questions or the prompts were, at no time was more than 50 words of the book ever used as an output. And then they also argued that the authors weren't entitled to control the market for licensing their books to AI companies, which I thought was kind of, if authors aren't entitled to not necessarily control the market, but they should be able to control their work and where it goes, because that's part of copyright laws. But anyway, that's Meta's position. And ultimately, the court reviewed the arguments. The court felt that the plaintiffs didn't lean on their strongest argument and that the ones that they did rely on weren't convincing. The court ruled in Meta's favor. And it's not because there was like a definite legal exception to it, but more because the plaintiffs, they just didn't present strong enough evidence of market dilution. But the judge did say this. The judge did say that this ruling only applies to the 13 authors in this case. It doesn't mean that Meta actions are lawful across the board. So there's really still hope, right? So even though they had this motion for summary judgment on that one issue, and most of the other claims were dismissed early on, the case is not over. Right now, the final issue that has to be ruled on is whether or not Meta actually distributed the works once they were downloaded. Because remember, one of the rights that copyright owners have is the right to redistribute. So what the plaintiffs are arguing is that when they downloaded the books, they had to re-upload them in order for it to, whatever the technical term, torrent, I don't know. I'm not even going to try to explain it because I'm not a tech person. But in the process of them trying to get the information to their training system, and actually, as I read it, it essentially said that it was so much information, right? It was so much information that they were trying to download that they had to do it in pieces. Like they had to create some type of network on different computers, and then each computer would have a piece, and then they brought those pieces together to make one document. And in that process is when the plaintiffs are saying that it was essentially uploaded or redistributed without their consent. That's the final part that the court has to rule on. And they just put out an order at the end of July setting some discovery dates for that. And the reality is this, that copyright law wasn't built with AI in mind, right? That's why courts, lawmakers, and creators are all kind of scrambling to figure out how to apply existing protections to this new technology. So right now, what we have, or what we don't have, there's no specific laws that says, hey, you can't use copyrighted content to train AI. Fair use currently is the main legal ground for fighting this. And AI companies are arguing that training models on copyrighted content is transformative and therefore legal. And creators are arguing that it's copying and that it's harmful to their market. And essentially what that means is when they're arguing that we're training our AI models on this and it's transformative, meaning that when we use it, there's essentially no trace of the copyrighted material. Like it's not like we're regurgitating this material. And what the authors are saying is maybe you're not doing that, but what you're doing is literally copying our work because this is our work and you're using it to train your models. And because you're doing that, you're just taking away an opportunity from us to earn revenue or income because we as a copyright owner should have the right to say who gets to train their AI using our stuff because it's ours. So, and we can make money from that as well. So that's the argument that's the fair use argument. In courts, they're just now getting to weigh in. I think that this case, seeing how that final point is resolved, I think that will be really interesting, and it's going to kind of determine how the future of how AI and training models and creative works can be used. I think we still need to keep an eye out for other cases that actually address the issue of fair use as it relates to training AI models. But this is what I say. I say that even without concrete law, you can still take steps to protect your work. First thing you can do is register your copyrights. Even though you don't have to register your copyrights in order for the rights to apply, when you do register your copyrights, it gives you the right to sue and it strengthens your legal position. Another thing you can do, you can add AI specific notices at the end of How to Train Your Dragon. I want to say the live action one that just came out. At the end of it, there's a note that says you cannot use this movie to train AI, to train your AI. So using notices like that, it's not necessarily enforceable. But if you have a notice like that, that's clearly signaling that you do not give consent for your material to be used. And if you have a future legal claim, you can use that to your benefit, saying that, hey, I gave them notice that I didn't want them to use it, that they did not have my consent. You can track how your work is being used. You can use tools such as Glaze, Nightshade, and Have I Been Trained? Those are some of the emerging softwares out there to detect AI training and output patterns. And then join the movement. Creators, publishers, and advocacy groups are pushing for stronger protections. Your voice matters. A local chapter or a national chapter or organization that is advocating for stronger copyrights for creatives. As a matter of fact, I would see what companies such as Pixar and Disney are doing, because Disney has historically been at the forefront of copyright change and copyright advocacy. So I would definitely take a look to see what they're doing. But as we wrap up today's episode, it's clear that the intersection of copyright law and artificial intelligence is anything but settled While the courts have started to weigh in, as we saw in this case, the legal framework is still catching up to realities of new technology. Creators have powerful rights to protect their work, but must navigate ongoing debates about what qualifies as fair use and how market harm is measured. For now, there's no definitive law stopping AI companies from training on copyrighted content. So vigilance and proactive measures such as registering your copyrights, adding AI-specific notices, and joining advocacy efforts are more important than ever. I do not disagree with that author on Threads that said they're not going to post essentially like their important work. I think hers was a dissertation. It's like, I'm not sharing that online for you all to go and train the AI on. I'm not doing that, but I will put other things on there. I will share other content that I write. At the end of the day, you have to make that decision of what you will and will not share. And I will say this, that although the jury is still out on what infringement looks like regarding AI, we are hosting a trademark infringement workshop on August 20th at 11 a.m. Central Time. I invite you to register for this workshop for insights on how to spot the signs of brand identity theft before it spreads, understanding what trademarks actually protect and how to claim yours, how to respond strategically when someone copies your name, logo, or signature offer name, and how to use informal letters and cease and desist letters to shut down infringement. Let's take this conversation over to ownyourgenius.co. I want you to share this episode with 3 people and have them join you there. But before you go, you know what to do. Make sure you hit that subscribe button and rate the podcast. Until next week, keep building your business, growing your brand, and owning your genius.